Half a day. The Committee on Health, Land, Justice, and Culture is now called to order. Today's Wednesday, June 22, 2022. The time is 10:35 a.m. In compliance with the Open Government Law, notices for this public hearing were published in the Guam Daily Post on Friday, June 3rd, and again on Wednesday, June 8th, 2022, and posted to the Government of Guam Public Notice Portal, and is being live streamed via the Guam Legislature's YouTube channel. Notices were also sent via email to all senators and all main media broadcasting outlets. Individuals testifying shall first be recognized by the chair before speaking and begin by stating their name for record-keeping purposes. We have one agenda item for this 10:30 hearing, that is Bill number 269-36 COR, introduced by James C. Moylan. It is an act to amend Section 89.13A and 89.13B of Chapter 89, Title 9, Guam Code Annotated, relative to mandating electronic monitoring of sex offenders on probation or parole. I'd like to acknowledge my colleagues who are here with me this morning, our Majority Leader, Senator Nelson, our Minority Leaders, Senator Dueñas, Senator Anthony Ada, and Senator Joanne Brown, and the sponsor of the bill, Senator James Moylan. So I'll now invite the sponsor of the bill to introduce the bill. Senator Moylan.
Thank you, Madam Chair, and thank you, colleagues, and also welcome to our interns joining us here today. Bill 269-36 Core, as introduced by myself, is an act to amend subsection 8913A and 8913B of Chapter 89, Title 9, Guam Code Annotated. It's relative to mandating electronic monitoring of sex offenders on probation and parole. Basically, the electronic monitoring device is a homing device and to be used by probationers and parolees who are under house arrest. As we know, many of our criminal offenders are eventually released from prison, and this bill specifically is addressing those offenders who commit criminal sexual conduct. The probation and the parole officers are mandated to, of course, monitor these folks or the criminal sexual conducts, those who are released or on conditional release before being incarcerated. But we understand that these officers are in high demand. There's a shortage of them, and yet we have so many criminals to oversee. Our island is, as you can see in the news articles, are faced with a lot of repeat offenders, recidivism. And though we hope to have reform them through educational classes or through their term while in prison, we're hoping that they turn their lives around, but criminal sexual conduct is such, for many, is a disease. And we can see from these news articles and the newspaper that it continues to happen. So in support of our parole officers and our probation officers, we understand that electronic monitoring devices are very helpful in deterring criminals, especially, and we're hoping even more so with criminal sexual offenders, from repeating the same offense. With that ankle bracelet on, to think twice before venturing out and not following their conditions of parole or probation. What really wants to be done with this bill is the safety of our community. So what the bill basically does is just change a few things in our existing law. It's just an amendment. Instead of saying may use the electronic monitoring device, it's basically shall. And that also the Territorial Parole Board shall require this as well for CSC offenders to have an electronic monitoring device placed on them while they're on parole. Yesterday, I believe, we had the opportunity to listen to the Judiciary of Guam present their budget bill, and there was a long discussion about the effectiveness of electronic monitoring devices and how it has helped in the deterrence of further crimes for those probationers who are in temporary release by pending their trial. On parole, and like probation, those on probation as well. It's a conditional release. And the monitor will be very helpful for those who committed the crimes or awaiting their trials to understand that they're being watched. This will be very helpful for our judiciary, as they earlier explained, but also for Department of Corrections too. And specifically, this bill is addressing criminal sexual conducts. In my past job when I was working for Governor Guam as a parole officer for 7 years, I can tell you that just about every person that I had under my belt were repeat offenders. And it's just difficult to keep up with all of them. And with the shortage of peace officers, I'm sure this will be even more helpful. So I ask my colleagues for their approval, or are there any questions on this? But I can see this being very helpful in the Department of Corrections, and likewise we understand Judiciary Guam is also in favor of this too. So I look forward to any questions we have. Thank you, Madam Chair.
Thank you, Senator. For the record, we sent special invitation to be present at today's hearing to the Supreme Court of Guam, the Judiciary of Guam's Probation Division, the Office of the Attorney General, the Public Defender Service Corporation, the Guam Bar Association, the Guam Police Department, and the Guam Parole Board. We received no written testimony, but we did receive two correspondence from the Supreme Court of Guam, which says, Hafa Speaker Terlaje, thank you for your letter with an invitation to provide testimony on Bill 269. I met with the Judiciary's administration to discuss the proposed bill. The administration is currently in the process of vetting the proposed bills. I plan to meet with the Superior Court judges for the comments and input on the bills. Written testimony will be provided within 10 days following the public hearing. So we sent them a notice of this hearing June 15th. We also received a response from the Executive Director of the Public Defender Service Corporation. Thank you. We will review and submit testimony. We appreciate the opportunity to respond to proposed legislation. Public Defender Service Corporation. Stephen Hattori. There is no one here to present testimony today on this bill. However, for those who are attending, I'd just like to point out, so the bill has one section, it amends a current law. The current law says the Superior Court may order a sex offender wear an electronic monitoring device for the duration of his probation. Part B says, if released on parole, the Territorial Parole Board may, as a condition of parole, require that the offender wear an electronic monitoring device. So it's may. And the bill before us is to change the words may to shall, so that there's no discretion anymore with the court, the Superior Court, or the Territorial Parole Board for probation or parole, that if it's a sex offender, that they shall be required to be monitored by electronic monitoring. We heard from the judiciary yesterday. The judiciary was in here for their budget, and they specifically requested additional funds to expand their electronic monitoring program. So prior to that, the law had been put into place to allow them to use electronic monitoring. And one of the bills that we had passed in the 34th Guam legislature that I had sponsored was to include as a condition of pre-trial pre-trial release. That's before you get sentenced, so it's before your probation and it's before your parole after you've served your crime. Pre-trial to allow electronic monitoring. So the court has told us that currently their program only is for defendants on pre-trial release. This is as of 2019. They are used for moderate to high-risk defendants. Those are sometimes defined as pre-trial violators or pre-trial felons. And that they don't specify what type of crime you have to have been accused of to be eligible for this program. So they determine whether you qualify for electronic monitoring, pre-trial, based on and whether you are moderate to high risk. And it doesn't matter whether it's sexual assault or any other type of crime that you've committed. And so again, that's the current program that's in place at the judiciary. It's for pre-trial. So before you go to trial, that's the pre-trial program, right? I mean, pre-trial time. Then you go to trial. After trial, you are sentenced. And then after sentencing, they can put you on probation. That can be part of your sentence. And when you are on probation, you are monitored. So the traditional way of monitoring is we've got probation officers, and they are in charge of monitoring you when you're on probation, making sure you're not getting into any additional mischief. And they go out in the field and they monitor, or they require you to come and check in periodically. And so that's their ways of monitoring. Sometimes they require you to do drug testing as part of their monitoring, right? That's after you've gone to trial and you have been sentenced. If you're sent to prison and you get out of prison, sometimes you get out of prison on parole. That's like an early release from prison. So when you get out on parole, it's a territorial parole board who gets to decide whether you're going to get parole or you're not, or you're going to stay in prison for the whole term. So, and then when they're out on parole, because they're out early, they also have to be monitored to make sure that they don't violate any conditions of their parole or commit any other crime. And so again, the traditional way to monitor them is, in the field activity of parole officers going out there and checking where you are, whether you are where you're supposed to be, requiring you to check yourself in periodically. That's another way that they monitor those who are on parole. So this bill mandates that the Superior Court and the Parole Board will use electronic monitoring, not just on pretrial and not at their discretion, but mandatory on probation, which is after your sentence and you're allowed to be out, or while you're on parole. If the crime that you had committed is a sexual conduct crime. So we don't have testimony from the judiciary today, but I did research their testimony in the past in regards to electronic monitoring on pretrial defendants. And their concern with that bill was in regards to how it may have affected efforts to properly assess, classify, and supervise pretrial defendants. And of course, at that time, they had not yet secured a contract, and now they have. And so we heard from their budget hearing yesterday how much it cost them to implement. So for 50, and they're currently capped at 50. So their proposal is that if the legislature is able to appropriate 652, they can increase that up to 100 defendants. But again, that's 100 pre-trial defendants. They made no accommodation yet for probation or parole defendants. The committee received a fiscal impact note from BBMR, which is the Government Agency Bureau of Budget Management Research, which is supposed to assess the fiscal impacts of all proposed legislation. And so they said on this bill, although this bill seems administrative in nature, correspondence with the judiciary of Guam indicates that a significant fiscal impact may be felt on operations. The daily rate for self-monitoring is $8 per client. Since the piloting of the EM, Electronic Monitoring Program, for pretrial release, there have not been any defendants placed on self-pay status. The judiciary further states that the EM program currently has 16 defendants, however, only 10 are currently on the program. In addition to those in the EM program, there are 82 additional active pretrial release cases for criminal sexual conduct and 22 cases serving a term of probation for criminal sexual conduct. The jury estimates minimum fiscal impact of 100 clients at $756,395. So if it's mandated, they're going to have to mandate expanding beyond 50, and so that's the estimate of the fiscal impact to the judiciary. So of course they're not here today, but I'm hoping in their testimony that they have said that they would submit, that they will answer, some of the questions related to this, including will they be able to handle a mandate of all defendants on probation for criminal sexual conduct, all parolees for criminal sexual conduct, and what those numbers are exactly. I wanted to ask them as well, how many of the pre-trial persons who are currently under the judiciary's electronic monitoring program are actually accused of sexual misconduct? Or are there other crimes that are being covered by their current program? And other than that, I'm going to open it up for the rest of my colleagues. Senator Nelson, questions or comments on the bill?
I do agree with the sponsor of this bill that in most cases, sexual offenders do suffer from some kind of mental disease. In just recent news, we were seeing even some of the rhetoric turning into those that are pedophiles should be labeled as minor attracted persons to take away the stigma of adults engaging in sex with young children or adults that are attracted to young children. And there have been a lot of discussion on this matter. Some of the discussion that occurs is that those adults that are attracted to young children or to children in their teenage years do need to seek medical help. And even though they do not act on the impulse, it is still considered a danger to society, especially to our youth. And we see this instance many times in our island. It's almost every week or perhaps every month we see a sexual crime committed against a child. We even see those that are put in places to protect children have sexual crimes committed against a child, and in some instances are released. And so to be able to monitor an individual during the probationary period is prudent, because adults have the ability to manipulate children, and they also have the ability to find ways to take advantage of situations. And so I support this measure. Thank you, Madam Speaker.
Thank you, Senator Nelson. Senator Dueñas.
Sidus Mase, Madam Speaker. And once again, I'm sure our listening audience is probably wondering why we're engaging this way. So I will mention once again, we are very pleased to have the summer youth employment trainees who are participating with the legislature and various senatorial offices with us here today. And particularly in the absence of testimony, we are engaging with these young people who have decided to spend some of their summer time with us, gaining more knowledge about the legislative process, as well as working, I'm sure, to earn some extra money to relieve your parents from the stress of having to provide. So congratulations for being such good children. So in this instance, my position is different than the last instance in terms of what the bill was calling to do and the complexities of it. I agree with the sponsor and the statement that you heard from the sponsor in terms of the position on this bill. And I think the speaker also laid out a very compelling discussion on what the potential of this bill to move forward would be. And of course, that would be that we anticipate we would be able to get satisfactory testimony from the judiciary and others who are invited in order to be able to make a decision in terms of fiscal impacts, which basically means providing monetary resources, right, to be able to help. This is a priority. This should be a priority for our community. So I don't see a reason why our legislature would not be able to ascertain what the additional resources would be required and to provide those resources so that the intent of this bill could be carried out, because you can see the importance of it. So in my opinion, this bill would more than likely be able to be placed after going through and receiving a committee report and being able to receive the testimony from the others who were invited, to be able to allow us to append that to this bill and go through the process, hopefully, and I'm sure most of you will see the process of actually a committee report being formulated, and then how that gets loaded onto the website and all of the checklist, which prepares a bill to be eligible to be debated on the floor. So in my opinion, with this bill, even with the absence, which is a little unfortunate, but even with the absence of those who were invited, the compelling nature of the bill and the safety and security of our community, particularly when it comes to these type of offenses, is so important that I believe we could move forward. And I think the author has done a good job in drafting this bill and providing additional protections. So in this instance, I would not have a problem unless for some reason, and this does happen, for some reason others who were invited wrote to the committee within the 10 days and had some extremely compelling argument as to why this would be problematic. Then of course I believe the committee would say, okay, send it out to the senators, have it reviewed. Look, this might be an issue. I'm going to ask the author to, allow us to have another follow-on hearing. I don't really see that happening in this instance. So in this instance, for the benefit of the youth who are joining us and engaging this process, I'm only one of 15, but as long as the testimony came in that we would understand the impacts of the bill, from all those, who would be affected by having to carry it out, then I would work with the committee to make sure those resources would be available. But I, for one, would have no problem moving this bill forward and preparing to have it eligible to be debated on the floor. And I think this legislation would more than likely receive overwhelming support. So with that, Madam Speaker, once again, thank you for allowing us to have this dialogue and conversation with our youth employees that are here today and understand the process going forward. So that would be pretty much my pending decision, having heard this bill heard today. And like I said, I think you're going to definitely see the process as we go into session of how the other mechanisms go forward in terms of this bill moving its way through the legislative process. Sijus Masi, Madam Chair.
Sijus Masi, Senator. Senator Ada?
Thank you, Madam Chair. Once again, I was hoping that the judiciary, or at least probation, would have been here so that we could hear testimony from them. Yesterday, we just had their budget hearing, and they spoke about the effectiveness of electronic monitoring. And I know that the current electronic monitoring is used for pretrial release, which is limited only to home use. So it tells the judiciary if the pretrial defendant had left the home. We have no current idea how much GPS monitoring would cost, because I don't think that's in use at this point. So if a parolee or the probationer left the confinement of their home, where they went within the community, we would not have that information, because I don't think, like I said earlier, that GPS monitoring is being used. It's just only for those that are confined at home. And these are the type of questions and information that we could have gotten from the courts or from the probation office that would had given us better information in moving forward with this piece of legislation and the use of it for sexual offenders. So, again, Madam Chair, I hope that we'll be able to get the courts or even the probation office to give us testimony and let us know what their thoughts and feelings on it, and give us a better idea for the effective of it, the effective use for it on criminal sexual conduct offenders. Thank you, Madam Chair.
Thank you, Senator. Senator Brown?
Thank you very much, Madam Speaker. I also agree it would have been helpful for the judiciary to be here, considering that they had a substantial increase requested in their budget. I believe for the last fiscal year, they were looking at a little under a couple $100,000 for monitoring, and what they were looking at in yesterday's budget was closer almost to $1 million with regards to this type of monitoring. And we were told certainly that the benefit of this is it would reduce the cost of incarcerating these individuals while they were on probation. Ironically, the Department of Corrections at the same time came to the legislature a few weeks ago to request an additional almost $10 million to their budget. So I don't know, that doesn't add up to me how we're spending less in one area and benefiting more in another. I guess that would require further review. With regards to this issue, I think I certainly would like a little more information. I'm not opposed to the bill. I think we're seeing almost on a daily, if not weekly basis. Most recently, we had a situation in one of our charter schools where an individual is alleged to have committed a sexual crime against a student. And as mentioned earlier by one of our colleagues, obviously it's unfortunate that individuals that have this type of tendency try to work or are in areas of where children are located, either in schools, daycare centers, positions of responsibility. I mean, we've seen that most recently with the church. We've seen that with the Boy Scouts in particular. And I think, of course, this is unacceptable to see this type of behavior in our society, and yet it exists, and almost like I said, on a regular basis. On our island, we see those that actually have been, caught and charged. That doesn't include those that are committing these type of acts in our community that we are not aware of yet. We certainly want to encourage victims of this type of crime to come forward, because we hate to see someone who does this type or has these tendencies to go back in our community and reoffend to harm other innocent children and other members of our community. So I'm open very much to supporting this bill, but I would like some more definite information with regards to the implementation of this type of monitoring. There's been talk for so many years in the court system about including this, to also include those that are repetitive, habitual offenders of DUI in our community. But I think we'd like the specifics of the cost. But I did want to ask the sponsor if he's aware what the individual cost is of this type of monitoring device, and what does it cost on a daily basis, and who actually is keeping track regularly 24 hours a day of these monitoring devices that are added to, are being included or added onto the physical presence of these type of offenders? Do we know? If the, Madam Speaker, if the sponsor, Senator Moylan, would yield to that
You could just state all your
question.
questions in your line of questioning, and then the sponsor will be allowed to close on the bill and answer.
Well, it would
to
be
him.
helpful if
I'm
he
not
could
going to
just...
mandate him.
I'm not asking debate, I'm just asking for information, as we would normally do on any bill. Is he aware, just so that he can elaborate for our information and for that of the public? That is my question. I don't have anything more to add. I just want to inquire. I think that would be basic information that would be helpful in making a decision of this bill if he did and could provide that information for us and for the public.
Thank you. So the sponsor will have the opportunity to close on the bill and answer your questions at his prerogative. I'm going to just add on my behalf another thing that I will be looking at this bill is there was an identical bill introduced in the 35th Guam legislature, and the judiciary at that time, because of the mandate, because it removes the discretion from the judiciary from may require electronic monitoring to shall require electronic monitoring for probation. In particular, the chief probation officer had submitted testimony showing the recidivism rates of persons who were convicted of rape or sexual assault and their recidivism rates while on probation. And they attach a study to that showing the recidivism study. But their conclusion is pretty much that sex offenders are less likely to be arrested for a new sex offense during the term of probation. Afterward, I think the rates show a 9-year follow-up. Well, they were less likely than other released prisoners to be arrested during the 9 years following release. 18% of sex offenders were arrested for the first time during years 4 through 9 after release. But after 15 years, it jumps from 5% recidivism to 24%. So it's that after probation, that period, and after that 9 years period, I guess that this study is showing that's when we might need some type of monitoring. But by then, their term of probation's over, their sentence is over, right? So that's kind of the cycle we're in. I agree with the sponsor that if we're going to look at which crimes we might want to require additional monitoring on, criminal sexual conduct are those crimes, because the studies show they're not cured in any. I mean, it's very rare that they're going to be cured in any type of the treatment that is available on Guam, available in prison today. There are instances of it where they have been rehabilitated, but it's the recidivism rate for sexual misconduct it's I think a high risk factor on Guam based on the evidence and based on the statistics. So we also did pass a law recently, or in the last couple terms, that requires that they do a very particular type of assessment at the Department of Corrections and at the courts for sex offenders, meaning a thief may be assessed a certain way as to how, if we release them, are they at high risk of reoffending, versus a sex offender, the risk of a sex offender reoffending, and the studies show are higher than other types of crime. So, the probation office, I'm sure, accounts for that in their monitoring that they are doing right now, and whether they think, so they put these electronic monitoring on pre-trial persons who are moderate to high risk. And so I think if we get some statistics to show us that the moderate to high risk also correlate to the sex offenders versus non-sex offenders, then that might be compelling, right? We'll see. So it's a type of crime, that's an issue, right? The risk of recidivism based on that crime, that's an issue. The ability of the probation office to monitor sex offenders on probation is an issue. The ability of parole officers to monitor parolees who were convicted and served their time for sex offense, that's critical. We need to know, are they able to monitor or not? And we've had some roundtable hearings in here where it was pretty shocking that we found that even those who are put on the sex offender registry, so we have a sex offender registry for those who are convicted of certain types of sex offense, you're put on that list for life. And even though their names are on that list, the monitoring of those people was at that time that we had the roundtable challenged, right? Not accurate, not complete, yeah. So they've assured us that since then they have changed their methods and that they are, have increased their monitoring of those on the sex offense registry, those on probation and parole. But that is why it's critical to have these people before us, and it's critical to really flush these things out. Because we want to use it, because electronic monitoring is more expensive, or it's got a cost to it, additional personnel and the cost of the contract that we pay for the bands themselves and the technology, and because of the costs, we need to use it selectively. So we want to know which crimes and which people do we need that for? Is it the highest risk ones that we're designating? And as so prior law, we authorize that family violence, sex crimes, that these are tools for the judges to use in their monitoring of these people. This bill would mandate that, so that's why we just need to flush that information out. And so now I will allow the sponsor to close on the bill and answer any questions that might have been posed. Senator Moylan?
Madam Speaker, if I may, just a point of information.
Senator Nelson?
Yesterday's budget hearing with the judiciary, who is the programmer for the electronic monitoring program. The electronic monitoring program costs $130 a day. They look to utilize for the upcoming fiscal year to include 100 clients of the electronic monitoring program times 365 days. So that was within their budget request.
Yeah, that's about $700,000 that they are asking for 4 additional personnel for 100 clients, and that's only pre-trial, so it doesn't include probation or parolees.
Correct.
That's the problem. All right, so Senator Moylan, you may close on the bill.
Thank you, Madam Chair. Thank you, colleagues, for the discussion on the bill and the questions there. And we do understand that we could have had a lot of the questions answered with the panel, but I'm glad to hear that they'll be submitting their written testimony, and possibly they can include a lot of the questions that we included today. From what we understand from Judiciary during their budget presentation, this is a successful program. They do have a lot more clients on pretrial release, and a lot more. The probation officers have a greater number of clients to oversee than the parole officers. The parole officers take care of those that have been incarcerated and then are eligible for parole, come before the parole board, successively are granted parole by the parole board based on their parole presentation on where they'll work, where they will stay, what kind of community service they will do, and what's their parole plan. There are much less parolees compared to probationers, and just that's how it works. And while they're in parole, or right before becoming on parole, they're incarcerated and they're locked down. The probationers are not locked down. They're out and about pending their trial. So they deal with a lot more probationers, right, violators. On the parole side, we have a lesser number, but still must be monitored. So this would still be just as helpful for them on the electronic monitoring devices as what we can see with Judiciary of Guam. I'm sure we can be able to make contact with the director of DOC and the parole board as well for their comments on this and probably answer a lot more of the questions. But I'm looking forward to this bill moving forward and getting the written testimonies, and I thank my colleagues for their comments. Thank you, Madam Chair.
Thank you, Senator. There being no other testimony for this hearing, we will consider this bill duly heard, and that we will, it is 11:16, and the hearing is hereby adjourned. Si Diyos masa.